Good morning. I guess one of the things I'm supposed to do is not get us behind before we start. So I want to welcome you to the World Conference on Combating Terrorist Financing. My name is Robert Strassfeld. I am the director of the Institute for Global Security, Law, and Policy here at Case Western. The Institute was created to serve as a locus of research and teaching relating to counterterrorism, peace, and security in a world that is regrettably insecure and conflict-ridden, and where people have come to question the importance and value of our liberties in the face of the need for security. The Institute is a constituent part of the Frederick K. Cox International Law Center, which I guess on behalf of them, I welcome you as well. I will steal just a moment to advertise one upcoming event of the Institute this Monday at 4:30. Jamil Jaffer, who is the director of the National Security Project of the ACLU, who has had his hands in the middle of an enormous array of very interesting litigation, will speak on torture, Guantanamo, Abu Ghraib in a lecture entitled Torture, A History of the Present. But that's not what we're here for today. So let me briefly introduce the symposium. The 9/11 Commission taught us a number of lessons about the issue of terrorism financing. First, the obvious, but all the same, important lesson that staging terrorist attacks costs money, and that one way to thwart terrorism is to dry up the source of resources. But what the Commission also pointed out was that that's not so terribly easy. For one thing, as the Commission noted, the 9/11 attacks were a relatively low-budget affair for the amount of havoc that the terrorists were able to wreak. That makes detection of money transfers difficult, as does the availability of not only traditional mechanisms and traditional institutions, but informal, creative, non-traditional institutions or mechanisms for money transfer as well. All of which means that it is incredibly important to be able to detect and thwart transfers of money to support terrorist activities, and that it's difficult, and there may be any number of kinds of collateral consequences when we try. So the goal is to be effective, efficient, and not to do harm to innocents, whether those are financial institutions who are burdened by regulation or individuals or organizations that are suspected wrongly in some instances of engaging in financial support or material support for terrorist activities. To put it differently, one might choose to swat a mosquito with a cannonball. You might be lucky and catch the mosquito on the fly, but your living room will never look the same again. Our panels today address these issues coming from a variety of angles. The first panel will address the question of formal financial institutions, the regulation of traditional financial institutions to monitor and intercept terrorist financing. We will then have a panel on informal funds, informal mechanisms of transferring and the problems of detection in those instances. Rick McDonald, who was supposed to be a lunchtime keynote speaker, was summoned by the G8 G8 deputies. I thought he made the wrong choice, but apparently they have more clout than we do.
He will suffer for this, though.
Stepping up on incredibly short notice will be Jeff Breinholt, who's doing double duty today. I'm not sure what topic you're going to talk about it. He's not sure what topic. This will be improv at its best. In the afternoon, we will have a panel on charities, the special problems of charities that are viewed as particularly vulnerable to misuse by those who want to give material support to terrorists. And then, penultimately, a panel on key developments in enforcement and asset seizure, and finally a closing keynote by Richard Barrett of the Al-Qaeda Taliban monitoring team of the United Nations. This conference would not have occurred but for the support of an awful lot of people. I'm looking around for the Yanowitzes, and I don't see them. So in their absence, I would ask you to, this conference is funded by a generous gift of the Yanowitz Family Foundation, and in their absence, if you applaud loudly enough, they may hear you. So I ask you to join me in thanks to the Yanowitz Foundation for their support. Thank you. But there are an awful lot of other people who also made this possible. First of all, the Association Internationale du Droit Penal, the AIDP, the International Association of Penal Law, with whom this symposium is part of a bigger project, a 3-day conference on terrorist financing, and an experts meeting that will produce a significant preliminary document which will ultimately produce a major statement from the organization on the questions of terrorist financing. I especially want to thank Jean-Francois Tony, who is the president of the conference, Nikos Passos, who is the conference rapporteur, my absent colleague Michael Scharf, who is chairing a different conference in Washington today, the American Society of International Law Conference, who could obviously therefore not be here, but was instrumental in bringing the AIDP and us together. All of the national rapporteurs who are here doing terrific, important work. All of our many speakers, Alice Simon and Nancy Cantor, are behind the scenes making all of this happen, and this would not happen but for their energy and their effort and their ability to make all problems go away. And finally, I cannot say enough about the role that Richard Gordon, my colleague, with the snide, clever comments, has played in putting this conference together. I think as the day goes on, you will see what a terrific job he has done. I anticipate that you will find this an illuminating and enjoyable day. And with that, I will ask you to thank all of the people who have made this possible, and I will sit down and get out of the way. So please join me in thanking you.
as the panel is getting set up, the very first thing I should say is I would like to thank Bob Strassfeld for the enormous amount of support and work he has done to put this conference together as well. So a quick round of applause for Bob. Those of you who are looking at your program might think that Craig Boyes was going to moderate this panel. As it turns out, he will be moderating the next panel. He had a medical issue that he had to take care of. Also, we're having trouble with Ricks, I'm afraid, today. Rick McDonnell is summoned to Washington to address members of the G7 deputies. Rick Small called late last night to say that he is having a family emergency and will not be coming today. He apologizes considerably. He really wanted to be here. He actually played a very important role in bringing everyone here today. So actually, unexpectedly, I will both be chairing this panel and acting as the moderator, and I will also be playing Rick Small in his role, which you will see. So the things that I say, just assume I'm not really saying them. Or the smart things assume I'm saying, and the mistakes assume that Rick Small is saying. So I'm just going to briefly introduce everybody. I'm so pleased, actually, to be here because so many wonderful people, old and they're not old. They've been friends for a long time, I'll put it that way. And it's just great to have them here. And I'll start with Sue Eckert, who actually you're not an old friend, but you're a new wonderful friend. So I'm actually going to have to look down to remember all the wonderful things that you've done. Right now, Sue is at the Watson Institute at Brown University, where you're, I guess, senior fellow, is that right? Sure. And previously, she had been Assistant Secretary of Commerce for Export Administration under the Clinton administration. But Sue has actually feel like I've known you for a long time because you've written so much on this topic, and I think I've read all the stuff that you've written. And it's just really exciting to have you here. Next, Hermann Krull, who is currently a visiting professor here at the law school, teaching a course on banking regulation. And I've known Hermann for quite a while. We were colleagues at the International Monetary Fund for quite a while, working, among other things, on money laundering. This is the pre-terrorist financing era because it was before 9/11, essentially. And Hermann has wonderful experience both as a regulator and as one of the regulated. He was head of compliance for Standard Bank Group in South Africa, and he was also Assistant General Counsel for the Reserve Bank of South Africa in charge of regulatory compliance. So it's good you can play both sides, I hope, of this question. Nina Nichols, who I truly have known for 20 years. I'm so pleased that you were able to come. Nina is currently Assistant Director, I think, for banking regulation and supervision at the Fed board, but has done many things before that, including working at Dewey Ballantine as a summer associate when I was a lawyer there, and we worked together there a number of years ago when Nina was only 4 and I was a little older than that. And Richard Gordon, who will sit down now, I guess, in Rick Small's place. And Sue, if you'd like to begin.
Sure. Thank you. Now, it had to be you, though, because now we're going to have to call you Rick today instead
Yes,
of...
Rick is
okay,
good.
All right. I want to thank Richard and his colleagues here at Case Western Reserve Law School for this opportunity, and also the folks associated with the AIDP. I think these kind of forums are very important for discussion and dialogue on better understanding of some of the issues that are entailed here. And I should say that in the program, Richard identified me correctly in terms of the Watson Institute, but in the program I'm still listed as a has-been in terms of the can you hear? It has been in terms of the Clinton administration. But for the last number of years, I have been at the Watson Institute at Brown University. And we have gotten into these issues primarily through study and work on the issue of targeted financial sanctions, which we began with the United Nations, working with them in the Interlaken process and a number of other, Bonn, Berlin, and Stockholm. And then from there, moving into targeted financial sanctions, targeted terrorist financing, and have collaborated with a number of people here, not the least of which is Nichols and others on some of that work. Since this is to be a discussion and not presentation, we're supposed to be discussing as a panel and with you, I thought what I would do is give some preliminary comments regarding the results of the CFT, Countering the Financing of Terrorism, initiative or efforts 6.5 years after it has gotten into full force, and then some thoughts, perhaps, maybe provocative, maybe not, about what issues and challenges still need to be addressed. First, I think that it's very clear that there really has been an impressive global effort to regulate the trans-border movement of money through the formal sector, through formal sector financial institutions. There's been new regulatory requirements on banks and financial institutions. Again, you know, it was based on the money laundering model, the AML model, which was to some extent taken off the shelf in the immediate post 9/11 period and applied to this particular issue domain. The increased reporting requirements in terms of SARS and other reporting requirements, which have led to a quite significant increase in the regulatory burden on banks and financial institutions. Probably some of you in the audience know far more about that than any of us do if you have to live with it. We had some interesting conversations last night with people who actually have to implement these provisions and trying to understand what they need from the government in terms of doing this effectively, I think is a very important dialogue. But in addition to the regulatory requirement, on a multilateral level, you really do have the formation of, in political science parlance, so we really have a regime, the makings of an international regime for countering the financing of terrorism. While the initiative predated 9/11, the 1267 resolution that passed in 1999 existed, and Osama bin Laden and Al-Qaeda and the Taliban were targeted prior to 9/11. It really has gotten into full swing with adoption of other Chapter 7 mandates, 1373 and a successive resolution since then. And it has really spurred the development of a quite impressive regulatory regime, both legal and regulatory instruments in a number of countries. I think sometimes we lose sight of the change when we're looking at half full or half empty. I think sometimes we lose sight of the positive things and just the amount of change. Prior to adoption of 1373, when member states were asked to report on implementation of Security Council sanctions, the sum total of the response would be, we've taken all steps necessary to comply. One sentence, you know, end of submission. It really has been a remarkable process to witness and to study of the interchange between member states and the Security Council through these committees and questions back and forth on how to put in place legal mechanisms, but also the regulatory means to implement these CFT measures. So we have definite results as a result of the efforts that have been taken, but how successful have these been? What's the result of these efforts, if you will? And here I just want to focus on a couple issues which have arisen and then leave you with some additional points. First, it's undeniably terrorists have adapted to the regulatory measures which have been put in place. They've changed their methods of fundraising. It's no longer through the trans-border movement of money, but primarily a lot of the terrorist groups that we see now fund themselves through criminal methods, and a lot of them are self-financed, the individual cells. So you don't have this massive movement of money across borders or through the formal sector. But yet our regulatory response is still primarily focused on the formal sector. And so there is a question of whether or not this is appropriate, or to some extent is some of this feel-good measures, which we can point to and say we've got this regulatory program in place, and that's what's being effective. But are we really getting at how terrorists now raise, move, and use funds? Is the regulatory effort missing the mark? The second point I would say is that there have been negative consequences, negative externalities, if you will, of some of the early decisions, and in particular here, the early designations. I think that some of the people sitting in the room can probably speak more than I can since they were part of the process, but there really was a concerted strategy in the aftermath of the 9/11 attacks, what has been termed by some as the Rose Garden strategy, a very highly visible public announcement of designations. It started 2 weeks after the attacks with an announcement by President Bush talking about launching the first, the financial front of the war on terror. And while it's entirely understandable, there were, even as the 9/11 Commission staff monograph on terrorist financing noted, there were problems with some of these early designations. There was a rush, there was different evidentiary standards which were used, and have led subsequently to problematic designations. The reason I raise this, it's entirely understandable at the moment that you take what you have, the tools you take off the shelf, and you engage in a process immediately to go after what you can. But the reason I raise it is because the result has been a complication of the use of the financial sanctions tool. And in particular, there have been a number of legal challenges, some in the United States, some around the world. As Richard Barrett's monitoring team in their reports every year note, they track the number of legal cases or legal challenges which have been levied. But it's primarily based on the lack of due process and human rights concerns for the designations. Now, some people say, well, these are terrorists, they don't have any human rights. Some countries say it's not a problem for us because if we find, if we have terrorists, if we find them, we kill them. But the fact is that there are fundamental challenges of whether or not the lack of an adequate due process mechanism at the international multilateral level, the UN, raises serious legal concerns which have impeded countries from continuing to add names to the list. In the Bundestag, for example, because of the degree of concern and because of the legal challenges, there has been an admonishment to not submit additional names until some of these issues are addressed. So the question, the reason I approach this as an important issue is because it challenges and potentially undermines the effectiveness of the tool of financial sanctions, which I think everyone will agree is a critically important tool that needs to be maintained. But if we don't deal with some of these challenges and we don't make some progress, then I think that we risk undermining the tool. There have been, to the credit of people in this room, there have been some changes. They have not actually gone as far as the process as a number of people, and in fact the courts would like. There is currently pending a decision that was made, an opinion by the Advocate General on the European Court of Justice, who has opined in January that the Commission should actually, the court should strike down a certain designation under the Al-Qaeda Taliban sanctions. And I think that's quite problematic from the perspective, even though it's advisory, that you have a whole series of additional potential challenges that, should that be upheld, what's to stop the new listings of the Iranian Revolutionary Guard and others from coming forward and challenging designations. So I look at it from the perspective of we have a quite important financial tool that we need to maintain, and therefore we need to deal with some of these issues. But as we move forward, I want to just throw out about four challenges that we need to take account of. First is that we need to have realistic expectations with regard to what CFT measures can achieve. And that is that, as has already been noted, conducting terrorist acts are cheap. That's not the entire amount of money that's needed. You need money for the financial for the infrastructure. So it's a much greater amount than just merely the money for attacks. But notwithstanding the rhetoric that has surrounded this issue, you can't really drain the swamp entirely. You cannot stop the financing, particularly as it comes to be more localized criminal financial means. This is, I think we need to make sure to understand this, the CFT tool, as part of a package dealing with counterterrorism measures, of which intelligence, law enforcement, diplomacy, even military action at times is going to continue to be the primary mechanism. So to some extent, I think that we have oversold or overemphasized the CFT tool as the primary tool. And I think that the measures and metrics which were originally used in the early days in terms of the number of designations, the amount of money frozen, is really not appropriate. That was something which, it was declining utility, But I think that we need to look at this more holistically in terms of realistic expectations. Second thing is that we still have a system which is based on the formal sector. I think we really need to undertake a comprehensive assessment of what the cost and benefits are. We've relied on this as an effective, as a tool and claimed effectiveness. 9/11 Public Discourse Project accorded it an A- grade, which is, I think, quite significant, given that there were really very few passing grades at all. But I think we really need to take a step back and try to assess whether or not we're achieving our results as best we can. The third thing is we need more focus on the vulnerabilities, which are not, at this particular point, the formal financial sector. There are trade-based money laundering, shell companies, the use of cash, et cetera. And perhaps rather than relying and pointing on the formal sector as the mechanism to deal with terrorist financing, we ought to be putting more effort into that. The fourth is the need to differentiate between groups. And these are terrorist groups that I'm referring to here. Al-Qaeda, as a global jihadi movement, is fundamentally different than the LTT or ETA, territorial-based groups. But yet we treat terrorists all the same. And so I think that we really need to address that and move to differentiate in some ways. And here, I think in particular, the challenge is to deal with the Hamas and Hezbollah issue as well. Because fundamentally, a lot of the actions that the United States has taken beyond al-Qaeda has been aimed at Hamas and Hezbollah, but yet there is no multilateral consensus on how to deal with Hamas and Hezbollah. But yet you get the criticism of the multilateral process because they're not targeting these entities. Well, there's no multilateral consensus. The consensus ends at al-Qaeda and the Taliban and associated groups. So that's an issue I think that we really do need to address. The fifth thing is really that we need new ways of working with the private sector. And this is, there's been a lot of lip service to the notion that we need a true public-private partnership. And I think the administration has been very good in terms of articulating that as a goal. But I think even as former administration officials admit, Bob Warner, who was the head of FinCEN, said it's really not happened. That we need better ways of responding to what financial institutions need in terms of information. Apart from public designations and then isolated incidents where the executive branch comes and talks to individual financial institutions, we really don't have a sort of a good handle on how to share that information. And I think what we risk here, too, is that the financial institutions, the formal sector, become cynical as to the utility of this tool because they don't see that what they're doing, when they're filing SARs and it's coming back and it's showing that there's not even money laundering, there's maybe immigration issues, tax fraud, things like that, which is what they're finding in the SARs, not terrorist financing, that undermines their confidence that what they're doing is actually useful. I should underscore that every financial institution and bank I've ever spoken to truly wants to be cooperative with this effort and but they want to be effective. They want not just to comply, but to be effective. So I think that that we need more emphasis on indicators. So we tell them what we expect and what to look for. I think we need more aggressive work on new ways of sharing information, and that's intelligence information. I think that the British are ahead of us in terms of being able to clear people and share information. And I know it happens sporadically, but I think it's something we need to work on. And then finally, I think we need also protection for companies, safe harbor, for when they do take action based on the information that they receive, that they're not liable for that. So those are just some preliminary thoughts, hopefully, that can kick off the discussion.
Thank you very much, Sue. And in fact, I'm now going to play the role of the global anti-money laundering leader for GE money, even though I only get a Case Western Reserve University law professor's salary. And actually, I would like to talk a little bit about, I think, your points 3, 4, and 5, starting with vulnerabilities, differentiation among different types of terrorists, and then maybe a little bit about safe harbors. But I think in our world of regulated financial institutions, we think of two different types of anti-terrorist financing measures. Number one is what what we call the Santa Claus is coming to town style, which is making a list, checking it twice, going to find out who's naughty and really bad. If at least you have a list, and it's provided by somebody, the government, by OFAC, or the equivalent government organization somewhere, or by the UN, at least we in the banking and the formal financial sector, we can actually check accounts and see if those accounts match somebody who's on the list. So we can at least do that. Now, maybe the people who are on the list, both physical and legal persons, shouldn't be on the list in the first place, and we'll talk more about that later, but that's not really a concern of ours in the regulated banking sector. We can do that. It's expensive because there are many Richard Gordons, for example, and it might be difficult to identify which bank account we're freezing, and of course if it's frozen for a long time, that can be a problem for Richard. He can't pay his mortgage, and then we fall into the problem that Cleveland is having right now with mortgage foreclosures. So there are serious problems there, but at least we in the banking sector know what to do. The problem, I think, comes with the requirement to monitor transactions for indicators that there is terrorism financing involved, which would be obviously in Special Recommendation 4 of the Special Recommendations on Terrorism Financing of the FATF. This is very difficult, particularly in the context of a lack of guidance and feedback from the regulators and from the government as to what indicators really do suggest, what are the typologies to suggest terrorism financing. Now, Sue, as you said, it seems increasingly the case that terrorists are financing their activities not from clean money, but from dirty money. So if, of course, I'm from, Richard Gordon, not Rick Small, are from Boston, and I recall when I was a child, the provost, the provisional ring of the Irish Republican Army, everywhere, particularly in Irish bars, but not just there. Of course, I was a little older when I was going to Irish bars, but they literally were there with a hat, and you knew who they were, and they would collect. They also had extortion rackets, particularly in South Boston, where they were collecting essentially illegal contributions. But at least if you have the terrorists financing terrorism through illegal activities, then our traditional anti-money laundering system could pick that up, is likely to pick that up, because at least we in the banking sector have been in the business of identifying suspicious transactions that suggest proceeds of crime and trying to cover up the ownership and the provenance of those proceeds. So that's something that we can do to a certain extent because of the third issue, which is the lack of feedback. We just don't get much feedback, even with respect to traditional anti-money laundering suspicious activity reports or suspicious transaction reports, for those of you who are not from the U.S. It's true not only in the U.S. that there's a lack of feedback, or might even say no feedback. This is true pretty much universally. Having looked through all of the published and some of the non-published mutual evaluation reports and other assessments of compliance with a FATA 40+9. And if you look at the criteria and the methodology for assessment with respect to feedback, you see that this is true of every jurisdiction, particularly all of those jurisdictions where we have branches and subsidiaries, that there's just no feedback. So what are we supposed to do? We wind up in this odd position of actually trying to keep a record of the suspicious activity reports or suspicious transaction reports we file, and then wait to see, has the government, have the police or somebody, an investigator, come and asked us for evidence with respect to this file, this person, the individual or the company that holds the account. That's how we get feedback. Or maybe somebody's been indicted who used to be a client, for a crime that involved money laundering. This really is not a whole lot of guidance. It's sort of doing it on our own. So I think this is a big problem. And if we're interested in identifying transactions and clients involved in financing a serious crime, the one that is identified, which is terrorism, we can wind up doing something else, which is identifying lots of false positives. And I have to bring up the mere fact that my former classmate is Elliot Spitzer. And I think it was reasonably clear, and I will defer to my colleagues here from the regulator side of things, but it looked reasonably clear when looking at the transactions that had occurred that he wasn't laundering money. It didn't look like he was getting a bribe. There was no, believe me, he comes from a very wealthy family, as I recall from when we were classmates. And I don't think he would need a bribe, but it was quite clear there was not money going into his account. There was money going out of his account, which would suggest financing of something. It wouldn't be a bribe. It didn't look like he was financing terrorists, but it looked funky, right? There were these shell companies, and that suggests money laundering when you have lots of shell companies. But it doesn't, when you look at it, it doesn't really look like money laundering. It sure doesn't look like terrorism financing. And yet, this resulted in a suspicious activity report. A number of students here at the university have been engaged in a project, here at the law school I should say, have been engaged in a project of collecting as many examples of terrorism financing as we could find. Not just those that result in prosecutions and reported cases, but lots of other instances reported in newspapers, even on blogs. We don't know whether there was actual terrorism financing involved, so you wouldn't want to go and publicize the names involved with these people. It could be slander or libel or both. But at least we were collecting as many instances as we could, and looked at them and said, gee, are transactions occurring sort of like you saw in the Elliot Spitzer case? And oddly enough, no, they seem to be just straightforward payments. Often, this is using the regulated financial sector, often where you do have a charity, and the charity has an account, and it simply makes a payment to a bank account somewhere else directly, or to another charity. There are no shell companies involved. There are no Elliot Spitzer-like movements of cash all around. It's just a simple, straightforward payment. How, other than us knowing, through the making a list, checking it twice, who the terrorists are, how are we in the financial community going to know that this suggests some sort of terrorist financing? I think it's a serious problem. Safe harbors, I don't know what they would be exactly. Certainly the materials that have been produced by the FATF, the most recent terrorism financing paper, which since Rick McDonald isn't here, I can say I thought was somewhat lacking in specificity, had a number of examples. I used to work for the International Monetary Fund, and as I said, back then when we would write papers, and we certainly wrote a number of papers on money laundering and terrorism financing, when we actually didn't have sufficient data to make a real conclusion, we would have a text box with an example. And you'd have a text box with an example. And here's an example. Do we know that it's actually representative statistically or in any other meaningful sense? No, of course we don't. Not because we didn't want to know. We just didn't have time, or we didn't have the tools really to collect this information, but we would do a text box. So I'm always a little curious when I see reports coming out, whether it's by the government or by some other organization, that have text boxes with examples. I'll just leave it at that. So having done my role playing, I will turn the microphone over to my colleague, Hermann.
Thank you, Mr. Chairman. Thank you, Rick Small. I, in fact, would firstly want to state that I absolutely agree with everything that Sue has raised. I think, and I'll address my comments to you more from the private sector hat that I had been wearing until recently, in terms of my experience and frustrations to a large extent in dealing with this particular subject matter. Without revisiting the arguments that had been forwarded at the time, even before 9/11, but also subsequently, as to why it is a good idea to involve formal institutions in this fight against global terrorism, I think we should not underestimate the cynicism that Sue has referred to, in fact, that still exists in formal financial institutions, and then I'm speaking particularly about the board's non-executive directors who are representing shareholders. And although they do understand the underlying, call it emotional argument, but also the rational aspect thereof, that banks or other formal institutions which we might be referring to are part of the armor of the law enforcement agencies. I think to this day there is a lot of resistance still amongst true capitalists, free marketers, to justify the cost-to-income ratio, because that is what drives the profits of banks. And unfortunately, I'll defer to Nina's views on this, because my experience in the United States has been limited. But unless you are able to convince the board that what we are doing, that the money that we are spending, is in fact producing results, not so much in terms of how many death sentences did we get for the terrorists or whatever, but just to in fact be able to quantify that in terms of the money that has been spent for installing a new search-based 410 suspicious transaction report system, in terms of the reputation of the bank, as far as its standing in formal government circles are concerned, and this obviously also translates into money and profits later on, but we have a real problem, and therefore I fully identify with the point that you made, and that Richard also repeated, is that unless there are ways of communicating with private sector institutions from government or authority-based institutions as to, well, specifically results, but I would also want to take a step back, that in terms of the expectations, the typologies that we should be looking for, you will have a half-hearted cooperation, if not in terms of lip service, but certainly in terms of motivating formal institutions to become more involved and to actually take this more seriously than it does. And I think one can also dissect this into a number of reasons for their cynicism, which once again I think was also touched upon by Sue and Richard, in terms of what type of terrorists are we trying to catch. Terrorists, as we all know, and coming from South Africa, I feel I have a special qualification when it comes to this, are viewed as terrorists by certain sectors within a geographical area and not by others. They might be regionally based, they might be internationally focused, and all of this just clouds the whole issue of what do we expect from our regulators, especially if we take it up to the next international level, and I'm sure we'll address that during the rest of the day. The next comment I would want to make concerns the whole question of effectiveness of the information that is being dispersed into the financial and social society that we find ourselves in, insofar as what the banks report. And I mean, I've seen a number of bank practitioners here today who would be able to actually give us much more solid figures. But in terms of the information that banks submit as far as suspicious transaction reports, or you refer to it as SARS, I've picked up, what happens to that? I mean, it is like dispensing information into the ether and you have no idea what happens afterwards. We had the opportunity, Ross Delston, who will be speaking later on today, came to give a guest lecture in the anti-money laundering classes that Richard teaches. And we had the discussion there, should formal institutions, banks, actually be part of a follow-up process? If so, why? What would be the reasons for that? And to be quite frank, and I want to repeat my point that I made at that particular lecture, at this stage, given the, how would one delicately describe this, the unfinished state of your CFT regime in terms of effectiveness information, do I as a, and I'm putting on my former institution, private sector hat, do I actually want to know what happens to the information that has been put out there? Because of the fact, and I think it also touches upon the point that Sue made with regard to the due process. As a bank, I have obligations in terms of bank privilege, in terms of the business that I take on for the client. Suspicious transaction reports are not necessarily until proven suspicious. Do I want to endanger the relationship with my client, especially when it comes to like charitable organizations, foundations? I was often faced with the situation where charities in the Muslim community were making payments with regard to whatever it is that they were pursuing. And I, as a financial institution, need to make the judgment call based on all our controls and processes whether to report this to the Financial Intelligence Center or not. And once I did that, do I really want to know that there was something suspicious or not? I mean, this is the question remains whether this is part of your private sector, of your banking process or program. I think with that, let me not regurgitate, because as I say, I really, I think the 5 points that Sue made are really the burning questions that we need to look at. Once again, I don't want to steal Ross Delston's thunder, but I think the one point that you made that Ross will certainly add a lot of value and insight on is the question of whether the vulnerabilities in the system. You know, are we only looking at formal institutions, or are trade-based companies, shell companies, and so forth? Where do they fit into this equation? And I look forward to that. Thank you for your time and your attention. Over to you, Nina.
Thank you. I think between Rick, or Richard, whatever he's calling himself, and Hermann, there were a couple of points where they said they would defer to me. I'm not going to address those, but if you really want to know, you can ask again after. But I did want to address a couple of points that have come up. I think all of these issues that have been raised are, you know, they're very critical issues to this whole area of counter-terrorist financing. One thing I just wanted to add, by way of clarification of some of the comments that have been made, the role, and especially as a follow-on to Hermann's discussion about feedback, the role of the supervisors of formal institutions, because that's my job, actually. I'm at the Federal Reserve in the Division of Supervision. And so what we do is we supervise, you know, the set of institutions for which we have authority for a whole range of things relating to safety and soundness and compliance as well. And in terms of our role in this area, where we're talking about the prevention, the detection, the enforcement of terrorist financing, we don't actually investigate terrorist financing. It's not down to us to go out and identify it. We don't use our examination process in the banks to root it out and say, okay, let's go into this examination and see if we can see some of that terrorist financing based on our typologies. We don't. We examine our institutions for compliance with law and regulation, and also for safe and sound banking activities for the safety and soundness of that institution. So this is actually obviously a much broader goal, but in which the banks do play this critical role. And as supervisors, we're there to see that they are playing the role that's been set for them by the regulators, the administrators, the Bank Secrecy Act, and also law enforcement. We play a role in that regulation too, on occasion, but it's generally not based so much on, you know, what we found in regard to terrorist financing, because that's not what we do. But that said, I would I would say that we work closely. We try to work closely, especially in crafting regulations, and we're kind of in the middle. I think it was, Hermann points out very rightly that the banks have been sort of co-opted into the law enforcement role, sort of part of the armor, I think you said, and that's true. We're kind of in the middle of that, and we do, I think, serve an important role in terms of passing on indicators. And we have, for example, an examination manual that guides all of the examiners of banking organizations in the United States for compliance with BSA, anti-money laundering rules. And in there we do have red flags. I'm sure if any of you have looked at those, you note that the red flags for money laundering are much longer than the red flags for terrorist financing. The reason for that is the dialogue that's been referred to several times already on the panel and is ongoing, is we're part of the request to law enforcement and to the people who know. Tell us what to tell the banks to look for. What should the examiners expect? Where should we be pointing the banks to? Because we can't tell them, but we would be happy, and it is our job to include that in our supervisory expectations and in our supervisory directions. So we kind of do have that important role. I think that in terms of feedback, just one thing I wanted to note about Hermann's comments, there's two aspects he mentioned, the forward-looking and the backward-looking. The one is, what do you tell your boards of directors of why it's like so great what you've done and therefore justifies all this more additional money and infrastructure in the bank? And then there's the forward-looking, which is, what's the feedback about the typology so that we can better craft our compliance function? And it does sort of look in two directions. I think as supervisors, it's very important that we help to what we can in terms of understanding the typology, understanding what's expected, understanding as banks build their risk assessments what they should be looking at. But we, of course, welcome whatever information, and we understand there are huge restrictions on that information in terms of what can be shared, of what's been found in terms of here are success stories for this regime that we've put in place. I'd like to touch on just two other points. One is, since the panel is about formal, what are we called? Formal financial institutions. We don't really have a definition of that, but I think it's worth noting that you do kind of have to unbundle things. You could come up with a lot of indicia of what's formal. Is it chartered or licensed by the government? Well, that's a huge number of things because most money services businesses have some sort of licensing. Authorized by the government to provide certain services, critical obviously for depository institutions. Backed by federal insurance. Have access to central bank services, whether it's payment or other services. So there's varying degrees, I think, of what a formal institution is. And for example, a money service business, it might be just a small corner shop, yet it's licensed, it's registered, and it's subject to a whole scope of compliance obligations. So I think you'd call it formal. On the other hand, it doesn't have what a large bank might have to deal with, which is an on-site examiner there looking over their shoulder all the time with a much broader panoply of sort of enforcement potential, enforcement consequences. And as Sue noted, and I think it's definitely worth discussion, a much broader, generally much broader range of compliance obligations. And part of that comes from the way that the exam process is set up, but also partly comes from just the rules that are in place. And I think that that's some place where we can be of assistance to law enforcement too. The banking regulation system in this country is pretty opaque, and typically when we meet with people and explain, there's 5, okay, we usually lose some people right there, and then when you explain about you got your state chartered banks, but you have 2 regulators for those on the federal level, but then of course you have all the 50 states, and then you have the federal charters, but there's more than one of those, and you definitely have a lot to understand. So from the standpoint of being the person who has to write regulations for this, you kind of need the supervisors to be in there to help sort of craft it. And where I think it would be really good is if we can sort of refine our understanding about sort of the different sectors within formal financial institutions, because they certainly don't coalesce as one big blob. And in fact, even even within, if you look at a smaller group, if you look at MSBs, they are in FinCEN's reg. There's noted at like 5 different kinds. But if you really think about it, the risks associated with check cashers very different from the risks associated with money remitters, different again from stored value and foreign currency exchange. So the more sort of refined we can be in terms of the compliance obligations and the risks we're looking at in particular types of institutions, I think the better off we are. How we accomplish that in the banking sector is I mean, for one thing that we've done, and we've done it in a big 400-page manual, is the risk-based approach, and which yes, this is never go anywhere without it. Yes, this is one way to do it, and it's sort of baked into our whole process. It's in a lot of the regs. The regs from the last, I would say, five years or so, very consciously take this approach. And we look for the risks. We look for the institutions to do a risk assessment. You're going to have incredibly different risk profiles at different institutions. They might be the same charter. They might even be the same size. But when you look at products and services offered, geographies, and customer base, you might just come up with a completely different risk profile. But that's what I think where it's really important, the work that we've done, and we should continue it. I think the risk-based approach is certainly here to stay. That's certainly how we do our examinations, and a lot of the discussions and dialogues that we find in exams are examiners and bankers coming to a discussion of how do you assess this risk, and that I think that's a very constructive dialogue. I think that's helpful. And again, the better we understand what are the risks, because we've understood what the typologies are and the risk, the risk of what, the more information we have about that, I think the better that can be done. I would say there's not a lot really in the pipeline right now. After the USA Patriot Act, I mean, the USA Patriot Act was huge, especially for non-banks, because it brought them under. There had never been a program rule. There had never been a SAW rule. That had been restricted. That's something the banks have lived with here since the program since 1987 and the SAW rules since 1995. So that was already there, those sort of cornerstones, but it added the customer identification program and, of course, private banking and correspondent banking. Although I don't know, I mean, the tie from there to terrorist financing, again, the more information we could have about that, the better. I don't know, if that's, obviously there's more areas that can be looked at, but there's no big new regulations but directed by statute at this point. It's been sort of fully implemented, so we're working with what we have for the formal institutions and however you want to sort of define those. But the more we get, I think, a really good close-up view that it's not all the same, and it's a really big patchwork of very sort of different risks in different pockets, and the better we understand that, I think the better job we can all do. There's one other point that I want to make, which is we've talked about institutions so far, which is appropriate. That's what the panel's about. But another concern, and particularly from the Federal Reserve as the central bank, is the payment system. And we talk about institutions, but you also have to consider the payments infrastructure. And I think that the comment that you made about the cannonball, about your living room never being the same, I think that is certainly a lookout for the central bank in the payments area. I want to hasten to say that's not my area. I'm in supervision, but we work closely with our colleagues in payments on a lot of points where they interact, and this is one, because you could achieve, that perfect, to block everything, get all the information, don't send anything. You could blanket the world with that kind of regime that would stifle the formal payment system and would, first of all, probably drive, people to, other alternatives. So the balance, every regulation that's ever been issued is some level of balancing of priorities. But I think when we issue, where we work on regulations and we implement the regulations in this area, when you have regulations that can impact the payment system, whether it's the funds transfers record-keeping rule, for example, or regulations affecting remittances, you have competing priorities. You have the cost of conducting a payments transfer. You have the efficiency of that. You don't want to have something in place that requires extensive manual intervention in a highly automated system. You want to have a functioning system, yet you also have the priorities that we have from the side of AML and counter-terrorist financing. But that's something that really has to be balanced. I think going back to in 2004 at the Sea Island G8 summit, there was attention to this very issue, and it was noted, you know, the impact of remittances and the growth of remittances across the globe, and you know, to the tune of, a couple of years ago, over $200 billion for, you know, well over 100 million participants in a year. And so the direction comes down: make those faster, make those cheaper, make those easier to do. Well, okay, but then you've got a policy side that puts the brakes on it, and I think that you have always competing priorities in this area, probably more than others. In addition to the efficiency, of course, there's also the privacy concern, so you have to calibrate all those things, I think, fairly carefully. And in the area of AML and CFT, whether it's remittances, cover payments, there's a lot to balance. So I'm done.
Thank you very much, Nina. That's so many things now that I want to say in my role as Richard Gordon and in my role as Rick Small. So since I'm both speaking here and chairing this, Jeff, yes.
Yeah, I wanted to pick up on something that both Sue and you said, Richard, and that is,
We are webcasting, so we
Yeah.
will only get picked up.
Yeah.
Your questions will only get picked up if you
Okay.
do it.
If you tie like this, a little bit good.
Thank you. So, yeah, I wanted to pick up on something. This is Jeff Breinholt from the International Assessment and Strategy Center. I wanted to pick up on something that both Sue and Richard talked about, and that is, my sense, at least from Sue's comments, is that there tends to be a consensus, at least multilaterally, that with regard to the economic sanctions, we need to mend it, not end it, if you accept that as the premise. And if that's the case, crediting notions that Richard talked about, the problem of false positives and the political problems that we're seeing with some countries that are fearful of being challenged on submitting names. I want to at least suggest for discussion purposes that it's possible that a lot of these challenges are tradecraft by groups that have an interest in not being designated. Prominent Saudi organizations which feel very empowered to sue Western scholars in frivolous defamation suits. And if that's the case, and if that's combined with the fact that I think even people who credit the notion that we need to be more accurate in the list-making approach, there still is not a solution to the dilemma that Hamas and Hezbollah both have political wings, charitable wings, in addition to military. And in the U.S., at least, as a matter of unilateral power, we deal with the problem by saying Hamas is a singular entity. Hezbollah is a singular entity, and even if you, as a donor, fully intend your contribution to Hamas or Hezbollah to be used for good things, it still frees up other money for bad things. And so I guess my suggestion is, rather than immediately assume that we need to tweak what we have, is there political will in the multilateral forum to push back and to avoid mass capitulation in the face of what might be frivolous litigation?
Okay. Let's see. Mass capitulation. Let me start by saying that in the work that we have done, my colleague Tom Bierstecker and myself have done, in dealing with members of the Security Council and then the broader UN membership on some of these issues, I have never once talked to someone who said that they just think that this whole thing is ridiculous and they just want to end the sanctions. So I do not think that, there is no, I don't even know if I like the mend, not end. I think that it goes more fundamentally to the nature of legitimacy of these actions, and that what we need to do is maintain the legitimacy of this particular tool, and therefore, because of that, we need to respond when there are deficiencies. And I don't, I'm sure that there are some legal cases that some people may consider specious or politically motivated. There are other cases, however, where it has been demonstrated that there's been wrongful listings I mean, there are mistakes made. Or if not mistakes made, the case has not been made for some of these entities. Al-Barakat is an example of something that was explained by the 9/11 Commission report, the staff monograph, as a tremendous effect in terms of the Somali community, in terms of remittances going back to a country. The UN used that particular Al-Barakat in order to transmit funding for its operations in Somalia. So I think that, with regard to some of the early designations and the challenges, the legal challenges, I think some of them are really a legacy issue, because I think that a lot of them took place in the immediate aftermath of 9/11. And in fact, what has happened is the multilateral process has gotten better with regard to statements of case, that the case has been made by the listing government of why it's necessary, and that therefore I don't think you're going to have as many of these challenges further on down the road. I think with the question of Hamas and Hezbollah, I mean, yes, the United States treats them, they're terrorist entities, and no U.S. person or entity or associated can deal with them. But we have a broader political problem because that's not the law for other countries. There is no UN Security Council resolution which requires countries to do that. So don't blame the system. Focus on the political problem that we have in convincing other countries of the need to do something on this. Richard may want to respond.
Well, and I think from the perspective of former financial sector banks, if the entity is listed and if the U.S. government or OFAC is saying you have to seize this account, you have to freeze the account, that's something that the banks can do, providing that they can identify that this actually the owner and controller of this account is a listed person. I think there might be additional political issues if, as in the case, say, of Hamas, where you have a branch or you have a correspondent bank in another jurisdiction that does not have the same rule. That's another question that probably needs to be sorted out with your supervisor, your consolidated supervisor, and supervisors in both jurisdictions. I think that the issue is where you have an entity, say a charity, that is not Hamas, that is not a listed entity, but it is making payments to a dodgy part of the world, to put it. I think, Sue, you said that there are the international terrorists, and then there are the sort of more regional terrorists. And this were not Al-Qaeda, the international terrorists, but the provisional wing of the Irish Republican Army, as an example, or at least as an old example, making payments to dodgy parts of the world where often, because they're dodgy, they have lots of needs. And say in the charitable giving area, just business, they need investment. So it's, what does the bank do with respect to making a payment or having a client from that part of the world? The easiest thing would just be to drop the client and to shut down the account. Now that could be a very bad thing from a geopolitical perspective if we can't send money to people who really need it in Sri Lanka, for example. So I think that's a serious geopolitical question. And if it is up to the financial institution to make this decision on its own, on a risk-based system, and just actually going back to putting my Rick small hat back on, when the FATF decided to move to a risk-based system in the most recent iteration of the FATA 40 and then the Special 9, and Rick happened to be involved in that. I was involved in that mostly from sitting and watching it go on. But I think that was a major improvement in a lot of ways to move to a risk-based system. But it doesn't really solve this problem in this area. Now, if you think going to the regulators here, as Nina was saying, that and this is true not just in the United States, this is true in most jurisdictions, it is the prudential regulator who has been put in charge of ensuring that the terrorist financing rules are put into effect. Now, it's bad enough, or was difficult enough, shall we say, to give prudential regulators who share the same goals, or pretty much the same goals, as the board of directors of the bank that Hermann has to report to, which is to keep the bank safe and sound. Right? Everybody agrees. The regulators and the regulated can pretty much agree on that. Unless, of course, you're Bear Stearns, but they're not regulated. But you know what I mean. There's a lot of agreement. Then you turn around and say, okay, we're privatizing some law enforcement here. You're going to have to find money launderers. Okay, well, then you become a cost center trying to enforce this. And then you've got the regulators who are concerned about prudential regulation, and now they've got this strange rule they're supposed to be enforcing. They're not, they're not experts in rooting out criminals. They're experts in trying to keep the bank safe and sound and the whole banking system and the payment system operating. All of a sudden they're doing that, so we extend it. And then all of a sudden now they're in charge of rooting out terrorists, or as Nina says, not rooting out terrorists, but at least ensuring that the bank has some sort of system that effectively does this. It's getting further and further away from what prudential regulators are supposed to do. And this overlap of interests, the sort of similarity of interest between the regulator and regulated, starts getting further and further pulled away, particularly with respect to expertise. And when that happens, even in a risk-based system, we wonder if this is the way to go, whether you aren't just going to wind up having factors that are easy to identify, such as, oh, it's a payment to a dodgy part of the world. Gee, what are you doing about, I mean, I've heard many stories where bank examiner is not from the Fed but from the OCC, and they're not represented here today, where a bank examiner has said, okay,
Did you say this is being webcast?
Yes. I've heard stories, no doubt apocryphal, from other jurisdictions other than the United States, where bank examiners have said, gee, we see this, you've got this transaction here with an export financing with an exporter in I think it was not Lithuania, Estonia. And gee, I just was reading in the New York Times that there are a lot of terrorists using Estonian companies to. So what are you doing? What have you done? Why are you not? Haven't you closed these accounts, or have you made an examination of these accounts? And it's like, what? What are you talking about? This sort of reaction. So that, I think, has unfortunate geopolitical effects, et cetera, or may anyway. I'll pause at that.
Well, actually, I'll just add one word about. We considered calling the risk-based approach the dodginess-based approach, but that didn't win out. No, the risks. To put a little more definition around that word, we look at it as legal and reputational risk, and that actually is a place where those interests can converge again, because it's well perceived now that not putting a level of expense into your systems and infrastructure can expose an institution to legal and reputational risk. That's very unfortunate, no less than in the operational risk area, where if you don't put in the systems that you need and your IT is weak and you have a breach, then you may not, in fact, have financial loss, but the reputational risk that goes with that can be significant. So that is a place where I think the interests do actually come back together again somewhat.
Jimmy?
Yeah, I have a question for Sue regarding the international designation process and the point that you made about due process concerns. The seventh report of the Al-Qaeda Taliban sanctions monitoring team that was issued at the end of November 2007, excellent report. 2 points that were particularly stuck out for me. One is that in 2007, just up to the end of November, there were only 5 designations, there were only 5 names added to the list, continuing a downward trend of designations. 5 designations is the lowest number of designations ever, since the process went into effect actually pre-9/11. Second point that really stuck out for me in the report was a conclusion that with respect to the freezing of assets, which is a separate issue, the designation is one thing, the freezing of assets is a separate issue, that 9 states account for 95% of the asset growth. Only 9 states, responsible for that amount, and suggesting that the states are not participating, they're not complying with their legal obligations to freeze the assets. Is that an issue of due process concerns, or does it raise questions on a much broader scale? Has the international community given up on the designation process? Has the sense of urgency that existed post 9/11 basically dissipated and no longer exists? Is a sense of commitment gone? And if there's more to it than due process concerns, then what needs to be done to revive this important component, a centerpiece, if you will, of the international counterterrorism strategy?
I would also add, I think that the Monitoring Chamber report is excellent. I think that Richard Barrett and his colleagues deserve a great deal of credit for really bringing these issues to the fore. And it is true that the number of designations and the amount of money frozen has steadily declined. In fact, even within the, you saw the administration citing progress of increasing amounts frozen up until about mid-2002, when it became clear that there were not going to be significant new amounts of money frozen. And I think that really is the result of the low-hanging fruit was gathered at that particular point. There were just not that many other assets to be frozen. So to the extent that that there are only 9 states that constitute 95% of the frozen assets, and the fact that there haven't been significant new ones, I don't know if it's fair to say that that's a result of a lack of international commitment, or the fact is we've dealt with the easy things first. And that some of the additional ones maybe, could be done. But frankly, getting Al-Qaeda, and again, this is Al-Qaeda, Taliban, and associated entities, we want states to come forward with new ones, but to a large extent, one would have thought that those parties had been amply notified that they are, the target or likely target.
5 names.
Right.
The designation.
Right.
5 names.
No, but in other words, I don't think that there are that many parties out there now who are still in the formal sector whose assets are remain to be frozen. If they had anything to do with it in the past, they've gotten themselves out of it, so there may not be that much.
Why are only 5 names worldwide being submitted to the UN Sanctions Committee for designation? And the report further adds that senior leaders, well-known senior leaders of the Taliban and Al-Qaeda that are known to the world are not on the list. Why aren't those senior leaders being submitted for designation?
Right. There it is, the question is this political will? I think that there is no doubt that political will has waned. And I think that that's a number of reasons. It's 6.5 years after the event. I think that the due process and human rights concerns unfortunately give an excuse to countries to say, well, we've got these legal issues, therefore we shouldn't submit names. That's, to my mind, one of the reasons why we need to deal with those other issues. There's also an issue, I think, beyond political will of capacity. And unless a number of states don't, simply don't have the administrative capacity to be able to name names, to be able to add them to the list, but even implement what's done. And so to a certain extent, you can't get to non-compliance or non-cooperation or political will, if you want, until you've addressed some of the capacity issues as well.
My last comment, and I'll be quiet. That may be true except for 34 states. And those are the 34 states that are member states of FATF. They cannot claim lack of capacity. I mean, these are members of FATF, and the FATF has passed on them. They're in compliance, or in full compliance with the 40 plus the 9, or largely in compliance. And there's certainly no excuse that these 34 states are not submitting names and blocking the assets of more than 5 people worldwide that are members of Al-Qaeda and Penal.
Well, that's new, and that's not total. In other words, they have the list that currently exists that they continue to block. So it's not like they're only blocking 5. It's 5 new ones that have been added. But I mean, frankly, I don't find it surprising. I mean, I think that there's a real problem with looking at designations and the amount of money frozen as a metric or an indicator of success, because I think it really is of limited utility. And I think that the administration realized that fairly early on. I mean, it went up to, the estimates, up to $200 million and then back down to 147 million. The 1267 committee, estimates are somewhat lower. But I think that what we've seen is in the discursive treatment that there has been an evolution of what the metrics are. And I think they're moving away from quantitative things in terms of designations and assets to more amorphous issues which have to do with, disruption, that have to do with deterrence, and things like that, which aren't quantifiable.
There's no names on the list. What's that going to deter? If names are not being placed on the list, there's no deterrent value of the listing process.
I think we're going to get into some of these issues as the day goes on. I don't want to monopolize.
I would just say something about metrics, though. It's kind of interesting. But for those of us who used to work at the International Monetary Fund, a number came out that was then quoted by everybody. How much money was being laundered each year, the proceeds of crime. What was it? Trillions, I can't remember. And it was always the same reference, and it was when our former managing director, Michel Camdissou, was at a meeting at the FATF, and he leaned over to someone and said, how much money is being laundered? I don't think he quite heard, actually, what the answer was. And so he came up with this answer. Now we're all sitting around saying, but he didn't really mean that. But that was the metric that continued to be cited until it's since been overtaken by something slightly more accurate. I guess Braddock first.
Good morning.
Oh, no, I'm sorry. You first.
Oh, sorry. Paul Beck with National City Bank here in Cleveland. My question, I guess, and I note that the topic here is issues in formal financial institutions, which would include us, of course. And we talked a little bit about this actually last night. And I guess the point that I sometimes come back to would be almost a competitive disadvantage when you consider the amount of expenditure in capital, human and otherwise, that we put into this. And to Sue's point, we'll continue to do it. We're happy to do it. Obviously, we have to comply, and I think we believe in the general idea. And I know we're going to talk about informal a little bit later, but when you look at, and you mentioned what I call the 5 families of regulators that we deal with, do you see differentiation in effectiveness? This is a loaded question, I know, but say between OCC institutions versus OTS versus other? I know we spend quite a bit of money.
As a means of not answering this question, I'm going to ask you a question. When you say competitive disadvantage, do you mean banks vis-a-vis other financial institutions, or U.S. institutions, U.S. banks versus non-U.S.? Because there are a number of ways to sort of cut that.
I would say both, but primarily the former.
Okay. Yeah, I mean, I think you can certainly point to some examples. Certainly, for banks, the compliance obligations have been the most long-standing, as mentioned before. And then, for example, the Customer Identification Program, which was a new rule that came in with the Patriot Act that was meant to apply much more broadly, at this point just applies to any entity that's federally functionally regulated. That includes banks and, of course, the entities regulated by SEC and CFTC, has not gone more broadly. So, yes, we can certainly understand that there is some unlevelness in the playing field. The level of examination between banks and non-banks, there's also some, and there's, to the extent there's burden associated with the exam and higher risk, because if there's violation, it will be revealed. There is that. On the other hand, as I mentioned in the beginning, there are different levels of benefit for different levels of formality, and for institutions that are really, are getting kind of the most benefit out of being the most regulated, whether it's through insurance or other access to central bank services, there is more that has to be done, and start with the call report that has to be done every quarter, extremely large reporting endeavor. As far as inconsistency among the regulators, that was the primary goal of doing our examination procedures as a single document. They're separate regulators, but everyone is a member of the Federal Financial Institutions Exam Council, so that was the goal there. And to do joint training, which every year no year has gotten the same fanfare as the first year with the big rollout, but just so you know, the training, now advanced AML training, continues to happen and continues to occur on a joint interagency basis. So one always hears about inconsistencies, but we continue to work on that.
Oh, I know it's a tough question to answer. And I note that you have what I call the Bible right there. It
Yes,
has a
yes,
prominent
indeed.
place on my desk,
Yes.
of course, as well. Thank you.
Braddock, once you get your microphone.
Yes. Braddock Stevenson, Case Western alumni. So it seems
But you're
like,
not going to identify your current employer, I understand.
right. So it seems that the question here is, trying to identify which transactions are terrorist financing transactions and which ones are, either just regular transactions or criminal transactions. And the panel seems to agree that there's a lot of similar typologies between terrorist financing and money laundering. Terrorist financiers are utilizing criminal methods as well. And so, it comes down to if, the bank's internal controls have it filed at SAR, then the question is, do they check that box? Do they check the terrorist financing box or not? And, one thing Richard proposed was, why don't we could provide a list of names or some other type of list or more typologies to, assist the banks, give them guidance in checking that. But would there also, I'd like to hear if there'd be benefit in maybe reducing the amount of SARs that are filed, the so-called defensive filing, and maybe having the government or, the investigators determine whether it's terrorist financing or not, if they can reduce the amount of SARs that are filed. And it doesn't seem that too much has been done to reduce, to prevent defensive filing. I've seen some scholarly articles on it, and I know there's something in the BSA, that manual that says you shouldn't cite a bank for not filing a SAR. You should look at their internal procedures and go from there. So I'd like to hear if anybody has any comments on preventing defensive filing.
I'm reminded of the lyrics of an old Bee Gees song that says, "I started the joke which made the whole world crying." What I'm wondering, and I don't have any particular view on this, but it was triggered by your question, Braddock, is in this offensive against terrorism, I would want to make the case that despite all the intervention and initiative of governments and international organizations and agencies, the banks have come to the party, the formal institutions, insofar as there are still, many flaws and the ground to cover. Insofar as what has been expected of them, they have come to the party, so to speak. And I think what has come out of remarks made here at the table, but also the point you made, and otherwise, are we not into a next cycle where the initiative, the energy should be coming from the formal governmental international institutions being charged with this, insofar as, and it will also address the very valid point, we've got 5 designations. Are we not lacking some impetus and some guidance from governmental and international organizations to actually refine and calibrate the search and the initiative that we are busy with? Putting on my private sector hat, I will definitely say so, but I really don't have a view, but I found it interesting because that is sort of the sense that I get out of the discussion and the points being made.
And I think that's just such an important issue, defensive filing, and I think it gets right to the question of what really is the role of the suspicious transaction reporting system, whether it's for money laundering or terrorism financing, and it's something that grew up a long time ago, and where the fundamental goal was, okay, the financial institution is in the best position to know its customer, right, to find out, to build a customer profile, and then to monitor transactions to see if they fit within what seems to be the legitimate transactions of the customer. That made sense, and it still makes sense right now. And for the financial institution to, as is required in the U.S. and as is required under the FATF 40, and to look for large, unusual transactions, examine them, write a little report, and then if they determine that there's suspicion, then to file it, whether it's money laundering or terrorism financing. But maybe we have moved beyond that. I might as well just say, speaking to people from OzTrack, for example, which is the Financial Intelligence Unit in Australia, where as far as I understand, their understanding of how the system works has changed. Yes, there are still suspicious transaction reporting requirements, as I've just described, but now they're moving to sort of give us all the information you can, and we'll make the determination, right? If, for example, in Austrac, and it might also be in TRACFIN, I can't remember, that all international transactions are reported automatically to Austrac. And they use, so what they do is through their data mining, they're able, by looking at every single, and it's inexpensive, it costs nothing for the financial institutions to do this, because they just automatically report everything, and then they do the data mining. And maybe this is sort of moving away from the financial institution as the investigator, as kind of the cop, and turning that more over to the Financial Intelligence Unit, at least maybe in this area. Then it's not a defensive filing of SIRs. It is just giving information to somebody who can then crunch all this data. And from all financial institutions, they'll get it, not just, if I'm a bank here in Cleveland, I only know my own customers. I'm not looking at the others. But if you have one person who could, an investigator, to look at them all together, maybe that's a slightly different path that we should consider going down, particularly since it's cheaper now thanks to data processing. We don't have to have individuals look at each one.
But that would merely make the bank the snitch instead of the cop. So, it does not really solve the moral dilemma that they have.
No. But they're the snitch now. That's the thing.
If I could just add one thing, because I think that I think the phenomena of defensive filings is extremely troubling from the perspective of really diluting the utility of the database. And I don't know, because I know that the executive branch had focused on, the significant increase, the increased incidence of defensive filing, and made an effort to try to reduce that. I don't know whether or not that's been successful. So to some extent, I'd be curious to hear from some of the financial institutions here today as to, how many times you have been contacted as a result of a SAR that you have filed. Do you feel like it's going into a black hole, or is the data actually being looked at and reflected in terms of investigations that are coming back to you?
In terms of sort of a defensive SAR, I think I don't remember there being an initiative to crack down on it and stop it. I do remember there being some level of inquiry of whether, in fact, it existed as a phenomenon. And I recall that the speech given to the ABA conference, not in 2007, but it was in 2006, by then Director Bob Werner, addressed this point. And I think that, in fact, I certainly never saw any data as to, we determined that these many of SARs were not actually reflective of suspicious activity, but they just threw information about a transaction into the database. I don't think that was where that sort of came down. As far as reducing filings, I don't know if there are any representatives of any law enforcement agencies here today. But typically when proposals have been made for a reduction of the number of filings, whether it's in the currency transaction report area or the suspicious activity report area, there's a certain reluctance to agree that that is in fact a policy goal. As Richard points out, now that you have great data management capacities, you can hold a lot of data. So if the banks could do it, the government could do it. As far as the taking away that evaluative aspect by the bank and making them just report, just give every piece of information, obviously there would be big privacy concerns to balance against that. It seems so unlikely now, but true fact. Right around the time that Know Your Customer was withdrawn, there was a legitimate legislative proposal to abolish the SAR database and never ever allow it to be reinstated. And it got a bunch of votes in Congress because that was pre-9/11, it was pre-huge public concern about terrorist financing, and that was the last time I can really recall that the privacy pendulum was sort of in the ascendance. And maybe that's gone forever, but I don't think that voice is completely stilled. So that would be a definite point for consideration with that proposal. Thanks.
Since Rick Small's not here, I might point out, he would if he were here, that his pre-9/11 proposal for customer identification regulation which he drafted, received the largest number of negative comments as a proposed regulation in the history of the universe.
Well, I think that
He
was the
didn't
first.
come out of his house for a week after.
That was the first time the FDIC accepted email comments, so maybe that was a bad one to start with. But Richard, let me say one other thing about the idea of just, okay, banks just be just big data dumps into into a database. That's okay, but then you do have to make sure that you're really specific about what the data is. You know, we always say, for example, in a funds transfer, once it's past the originator's bank and it's to the intermediary bank, it becomes much more difficult to go back to that original originator and get any additional information that you might want to clarify the background, the source, the purpose of the transaction. And so I think you'd have to consider, unless you were really specific about what went in there, do you want the government then reaching out to people who went to their bank to put in a transfer, and then they get a call from a government agency saying, we need to clarify why you're sending this money, and I think that you would definitely need to address that potential.
I think Allison was, and then our representative of law enforcement.
Thank you. Alison King from the European Commission. In answer to this point about the decreasing number of designations, I'd like to highlight something that's often forgotten, which is I think that sanctions are, as Sue said, just one mechanism among many. Speaking as a lawyer, the definite preference is for criminal prosecutions wherever possible. And I think some of the sanctions immediately after 9/11 were seen as a bit of a stopgap in response to a legal gap which did exist in a lot of countries that hadn't fully criminalised terrorism and all the associated acts. And I think that gap has to a large extent been reduced, certainly in European countries. It's not the case that all European countries are going to be able to bring prosecutions in any given year or whatever, but it is certainly happening. And that certainly has its deterrent disruptive fact, leads to final determinations of fact in any given case. And of course there are no issues as regards human rights because the full rights of the defence would apply. That's just an observation. Now, perhaps a slightly provocative question, if I may. There have been a lot of popular economics books and articles recently about our attitude towards risk and how it's fundamentally irrational. And there's the book on the 1% risk doctrine. So there's a 1% risk of something terrible happening. We have to take whatever action we can to stop it. And there's a sense, perhaps, 6, 7 years into this regime, that perhaps it was exempt from some of the normal rules of good regulation, better regulation. You have a very, very quick legislative process without any consultation with those affected, without any proper impact assessment, all the rest of it. The due process issues, certainly the cost-benefit issues. I mean, I see that in an area where diplomats, politicians are quick to agree things which are essentially dumping the costs on the private sector. And while I, as a practitioner, have dialogue with the private sector, I know it's not enough, and I would really like the private sector to be speaking more to the decision makers. Then there's all the unintended consequences, the risk that by doing what you think is necessary to stop something really bad, you're causing something even worse to happen, which Richard alluded to. And then the whole question of whether you're hitting the right targets in the first place. So, perhaps 6 or 7 years into this whole regime, I think there is a growing sense that we need to return a bit to the normal rules, to the normal ways of setting up our structure to make this something which is a long-term, sustainable, supported part of the compliance or regulatory landscape. Would you agree with that assessment?
That's certainly, I would agree with that. I mean, that's what I was talking about in terms of undertaking a comprehensive assessment. I think in the immediate aftermath of something so tragic as the events of 9/11, it's very difficult to respond rationally, and you do take off the shelf those tools that you have available. But what has been interesting, I think, is how there really has been no oversight or desire to really reassess this process. And it may be for a number of reasons. One, sometimes sanctions, to have a life of their own, and it's easier to point to the fact you have them than really consider whether they're effective. I think that's a natural response. But I think it's also, there's been political utility in terms of this process, or in terms of the whole initiative, to say, well, this equates to success in the war on terror. and I think, therefore, there has been a reluctance, at least at executive branch level, but it exists in the congressional branch in the U.S., too. I mean, there has been no serious questioning and consideration of what the successes have been, what the measures are, what's appropriate, looking at the costs, et cetera. So it really has escaped, if you will, I think, sort of a rational analysis. And I'm not overly optimistic that in an area which is a critical security area, that cost-benefit analysis works well. I mean, because it's always weighing it against risk and the security concerns. And so, you know, even if there are costs, whatever the costs are, they're likely to outweigh it. But it hasn't really focused on whether or not what we're doing is as effective as we could be. And so that's where I think now we have an opportunity to take a step back and say, what do we need to do to retool what's worked, what hasn't worked, and what do we need to do to actually make this regime more effective?
Say yes, yes, mais oui, certainement. Hanji in Hindi. I want to get to, I would go into greater depth. I would say Bob Strassfeld and I have had this discussion about risk and people's misperception of it, et cetera, many, many times. So, but I'll skip to it so that
Wait, Richard, can I say one?
Oh, I'm sorry, Nina, yes.
Sorry. I would just add to that yes, I think that's true, that the statute, you know, that the USA Patriot Act passed very quickly, but at the same time, no one ever suspended the APA with regard to any regulation that was issued, and every regulation that came out at least once. There was ample notice and comment, and certainly with CIP was put in the legislative history. It has to build on existing best practices. That's what it did. The final rule was significantly changed, actually. So I know what you mean, and I certainly appreciate the point. But I would say that certainly from a regulatory standpoint, there's not been a major departure from our practices in terms of notice and comment and that whole process.
Could I add 30 seconds? I fully agree, and I would want to consider my previous remark or observation amended by the point that Alison brought out, and that is that in revisiting the consultation process between the formal institutions, however they are defined, and the policymakers should in fact be enhanced in order to up the level of effectiveness, because in the end that is what it's about.
Sorry.
Thank you for your comments. I'm from the black abyss. And by that, I want to explain where I'm coming from. My name is Richard York, and I'm the Director of Enforcement for the Kansas Securities Commissioner's Office. Now, you all are wondering, what the heck does he have to do with this? Well, money is laundered through securities accounts. There is no doubt about that. And I've been with this agency for 23 years. I want to describe the black abyss that you all may or may not know about. I serve on the SARS review committee in Wichita, and that is actually conducted by the U.S. Attorney's Office, and I think the structure is probably similar for every state, and that the U.S. Attorney is responsible for putting together a team to review the SARS. Now, what do we get? What do we review? If you take one page of this and take out all paragraph punctuation and put it in 8 font, that is what we're reviewing. It's very small print. It's very difficult to read. And for you folks that file lengthy SAR reports, it's horrible to try and read through. The team. I am one of 2 state regulators that serve on the team. The rest are coming from IRS Criminal Division, FBI, Secret Service, ICE. You know, I could keep throwing out the 3-letter names. There are about 14 people that every month review. We get a printout of roughly 300 to 400 of these, an 8 font print. I spend about 6 to 8 hours reviewing that list before I go to the meeting, and so does every person that goes there. Every person reads the same massive SARS report, and we are not even known for our financial inclination in the south half of the state of Kansas. So the Kansas City area would have even more than that. That's the people that are attending. There's probably at any given time 6 to 8 people that can't attend because they're in court on cases. You have no idea how small of a SAR report, what a difference it could make. One of them that I'm handling was a man from just south of Wichita, 70-year-old man, and what he did was he basically forged some bank letters that gave validity to some securities that he was trying to sell. These happened to be Japanese promissory notes and were being marketed at $1.8 billion. Now, the bank almost didn't file the report because all they were concerned with was not the dollar amount. They didn't even know the dollar amount was a forgery on their letterhead. About 25% of all SARs that we review have to do with forged or altered or non-existent Social Security numbers. And for me, that's a complete waste of time, yet I read every one of those. And the rest of them fall into various categories of money laundering, check kiting, international wire transfers. All of them are suspicious to somebody. The fall down of our system is that the investigators that those get assigned to, and every one of those is kind of doled out. Okay, is your agency going to handle it? Is your agency going to handle it? So a representative says yes or no, and it goes on their list, and they're accountable for it. But the fall down is they don't report back to the banks. Many times we don't need your SAR report. We don't need your information because this is already a target on a major case. We're already working on it, and we don't need the final icing that's on the cake. We've got the whole cake. So, and sometimes it's just out of sheer volume that you're never contacted. The few banks that I've contacted where it's usually the compliance officer or the bank's attorney, they are so appreciative. And we appreciate that. That's kind of a general picture of the black abyss. And we appreciate the filtering that goes on. It would be better if we saw better filtering at lower levels, at the federal level, where they're sorting these better for us before they come to us, but they don't. They just give them all in bulk and then do with as you will and what you will. And our resources aren't increased to handle more and more, but there are a lot of them that are coming to us. But we appreciate your efforts.
Well, thank you very much from the Black Hole. And we'll break now for coffee.